This is Barry Zalma on Insurance. I'm an attorney who is retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to speak about the ethical burden on attorneys when entering into settlement negotiations. Settlements of litigation, whether funded by insurance or not, raise ethical issues that all parties and their attorneys must deal with before a settlement is effected. The decision to settle belongs to the plaintiff. This is especially important in cases with multiple parties and multiple attorneys. The Third U.S. Circuit Court of Appeals, for example, received a proposed class action suit against a group of attorneys from southern states brought by more than 2,600 former clients from northern states who say they were cheated out of their fair share of a $400 million asbestos personal injury settlements in the Mississippi state courts when the attorneys gave larger payouts to southern plaintiffs. The northern plaintiffs claimed that their share was reduced because the southern attorneys wanted to allocate a greater percentage of aggregate settlements to southerners in order to minimize the percentages paid to the northern plaintiffs' local counsel. The plaintiffs in the case called Huber versus Taylor were steelworkers from Pennsylvania, Ohio, and Indiana who joined a massive Mississippi asbestos suit. The defendants were attorneys from Mississippi, North Carolina, and Texas. The suit alleged that the northern plaintiffs were never made aware of a complex series of agreements between and among the attorneys that they say ultimately led to their receiving smaller payouts than the southern plaintiffs. The northern plaintiffs had all retained attorneys in their home states, referred to in the case as local counsel, who had in turn struck deals with a Texas attorney who served as co-counsel. According to the suit, by cheating the northern plaintiffs of their fair share, the southern attorneys saved more than $10 million that would have been paid to the northern client's local counsel. Reversing a lower court's decision that dismissed the suit, Senior U.S. Circuit Judge Jane R. Roth issued a stern lecture to attorneys about the duty of loyalty. She said, quote, "We are embarrassed to have to explain a matter so elementary to the legal profession that it speaks for itself. All attorneys in a co-counsel relationship individually owe each and every client their duty of loyalty. For it to be otherwise is inconceivable." This is Huber versus Taylor, Third Circuit in 2006. Judge Roth made clear that the fiduciary duty that an attorney owes clients is not a matter to be taken lightly. The duty may not be dispensed with or modified simply for the conveniences and economies of a class action. Among the conditions imposed on all attorneys is the ethical obligation to give clients full and meaningful disclosure of conflicts of interest, so that they may decide if the representation is in their best interest, and of the terms of proposed settlement agreements as it is the client's, not the attorney's, decision whether to settle a case. Under Texas law, a client need not prove actual damages in order to obtain forfeiture of an attorney's fees for the attorney's breach of his or her fiduciary duty to the client. But Judge Roth found there was evidence that the settlements were, in fact, aggregate, and that the plaintiffs may have a valid claim under Texas law for breach of fiduciary duty, that it could entitle them to a disgorgement of the Southern attorney's fees. This would really hurt the lawyers in their pocketbooks. While North Carolina does recognize a standalone claim for breach of fiduciary duty, it never has recognized a claim to apply to an attorney acting within the scope of his or her representation of a client. That duty, of course, does not apply to other parties to the suit. Under American Bar Association Model Rule of Ethics 4.1, an attorney representing a party may not make a false representation of fact. However, an attorney may, as part of negotiation, refrain from disclosing a client's negotiation goals or willingness to compromise. If attorneys were required to disclose their client's goals or willingness to compromise, it would be difficult to resolve any lawsuit, any more than one can win a game of poker if all of the cards are made visible to the other players. When negotiating with the other side, it is appropriate and common to include what is sometimes called puffing. Puffing is generally not considered a false statement of material fact under the rules. The ABA Ethics Committee distinguished ABA Model Rule 4.1a, which prohibits an attorney in the course of representing a client from knowingly making a false statement of material fact to a third party, from ABA Model Rule 3.3, which applies to statements made to a tribunal, such as in binding arbitration, and ABA Model Rule 8.4c, which applies in general to conduct involving dishonesty, fraud, deceit, or misrepresentation. The committee noted that Rule 8.4c does not hold attorneys to a higher degree of truthfulness than Rule 4.1. The committee further emphasized that it is never acceptable to lie to a judge. If a judge were to ask about the limits of settlement authority given to an attorney by a client, the attorney may decline to answer, but may not answer falsely. By contrast, the committee concluded that posturing and puffing are acceptable between opposing attorneys or with a neutral mediator. An attorney may downplay the client's desire to settle or overstate the strengths and understate the weaknesses of the client's case. Nonetheless, an attorney may not misstate facts, such as knowingly misstating applicable insurance policy limits. It is well-settled law, regardless of jurisdiction, that attorneys owe their clients a fiduciary duty. This duty is not to be taken lightly. It may not be dispensed with or modified simply for the convenience and economy of a class action. Now, some states have attempted to impose liabilities on insurers. For example, in Movesian versus Versicherung, a 2009 decision of the Ninth Circuit, the Ninth Circuit Court of Appeals concluded that Section 354.4 of the California Code of Civil Procedure, which was written to extend the statute of limitations until 2010 for claims arising out of life insurance policies issued to Armenian genocide victims interfered with the national government's conduct of foreign relations. The district court's order denying the Rule 12b-6 motion to dismiss was reversed, and the case remanded to the district court to dismiss the suit. Substantial factor causation is the correct causation standard for an intentional breach of fiduciary duty. As the court stated in Stanley v. Richmond in 1995, it is plaintiff's burden to establish a reasonable basis for the conclusion it was more likely than not that the conduct of the defendant was a substantial factor in the result. The authors of the Restatement Third of the Law Governing Lawyers recognized that causation for intentional breach of fiduciary duty might be treated differently from negligent breach. Under generally applicable fiduciary law, a claim of intentional breach might render applicable different defenses in causation and damages rules than would otherwise control. This finding is similar to a decision of the U.S. Supreme Court that recognized for the first time that presidential foreign policy itself may carry the same presumptive force as a federal statute or treaty. Consider American Insurance Association versus Garamendi, a 2003 decision of the Supreme Court. In Garamendi, the Supreme Court refused to allow California to create a separate foreign policy by allowing victims of the Holocaust to sue insurers for benefits not paid to the victims. The preemptive power of the federal policy is not derived from the form of the policy, but rather from the source of the executive branch's authority to act. Presidential foreign policy only carries preemptive weight when the executive authority is validly exercised. In prior cases where the presidential policy at issue implicated criminal law, an area traditionally left to the states to regulate, or foreign commerce, an area delegated by the Constitution to Congress, the court has refused to accord the policy preemptive effect. The Ninth Circuit explained that with regard to the Armenian genocide, however, the presidential policy concerns national security, a war in progress, and diplomatic relations with a foreign nation. The Constitution squarely, if not solely, vests these powers with the executive branch. The President acts well within his constitutionally delegated powers by developing and enforcing the policy, refusing to provide recognition to an Armenian genocide. However, when federal executive or legislative power is not involved, a state can change contract terms and revise the applicability of previously stated statutes of limitation. For example, 20th Century Insurance Company versus Superior Court of Los Angeles found that the California enacted Insurance Code Section 340.9, and that by doing so, the state chose to extend the limitation period available to insureds to file a lawsuit, notwithstanding any other provision of law or contract, for any insurance claim for damages arising out of the Northridge earthquake of 1994. According to the Court of Appeal, claims for which the applicable statute of limitations had expired were revived for a one-year period commencing on the effective date of the statute. This video was adapted from my book, Zelma, on Insurance Claims Part 107, Second Edition, which is available from Amazon.com as both a Kindle book and as a paperback, and is part of a 10-volume treatise Zelma on insurance claims. If you found this video interesting or useful to you or your colleagues, please refer it on. It's free. And please subscribe to my Rumble channel, my YouTube channel, and my blog so that you can learn of future videos and blog postings. Thank you for your attention.